Thank you, Mr. Chairman and Ranking Member Cole. It's regrettable whenever the Select Committee needs to take the time of the Rules Committee. It's regrettable because it's a result of someone blatantly ignoring the rule of law and undermining the investigative and oversight authority of this body. Today, we are talking about Dan Scavino, Peter Navarro, two former White House officials. In this case, it's also regrettable because the situation is so clear-cut that the House should adopt a contempt resolution by unanimous consent. This distinguished committee shouldn't have to spend an afternoon debating it. The actions of these men are so blatant and brazen that no member of this body should doubt that they are in contempt of Congress. Dan Scavino and Peter Navarro were two of the ex-president's senior advisors on January 6th, and in the run up to that date, Mr. Scavino was Mr. Trump's top communications aide. Taxpayers paid him to hold the keys to the infamous Twitter account. Mr. Navarro was a trade advisor, but whose activities severed far outside that lane. Both of these men have refused to comply with the Select Committee's subpoena in any way, based on assertions of executive privilege. First of all, the Select Committee wanted to ask both of them questions dealing with matters that clearly fall outside any possible claim of executive privilege. To put it plainly, they were both involved in efforts to challenge or overturn the election. Last I checked, a president's attempt to stay in power after the people voted him out of office aren't the sort of things where executive privilege applies. Secondly, and here's where it gets a little more complicated, neither of these witnesses has properly asserted a claim of privilege. That's lawyer talk, so let me put it more plainly. If you're a witness in some sort of legal proceedings, it may be a criminal investigation, it may be a civil lawsuit, it may be a congressional probe. You may get a subpoena, an order telling you to show up at such a place and such a time to answer questions. You have to show up. That's the law. Now, when you show up, there are a few reasons why you may not have to answer questions. Witnesses have the prerogative to raise constitutional rights in response to congressional inquiries. For example, we all know the phrase, pleading the fifth. That means someone refuses to answer a question because the answer may subject them to criminal prosecution. The Constitution protects us from answering questions like that. And then there's executive privilege, which makes sure a president's sensitive conversations about official government business stay confidential unless outweighed by congressional investigative needs. These are important privileges. Witnesses have the right to assert them, and the Select Committee respects that. We follow the rules of the House. The rules lay out procedures for considering lawful assertions of these privileges. But here's the thing. If you want the protection of any of these privileges, you have to show up and explain why. We have had plenty of witnesses who fall into that category. We've had witnesses who've shown up and to every question claim their constitutional Fifth Amendment rights, asserting that their answers might subject them to criminal prosecution. The Select Committee respects those claims. At this point, none of the witnesses who have done that are facing any criminal contempt citation by the House. I think we'll hear a lot of attempts to muddy the waters about privilege claims, especially when it comes to Mr. Scavino. That's his lawyer tried to negotiate with the committee, that he wanted to find a way to come in, but he had such grave concerns and reverence for the institution of the presidency. At this point in our investigation, there's a mounting body of legal rulings rejecting the ex-president's claim of executive privilege. That makes Mr. Scavino's claim thin to begin with. Mr. Navarro are even thinner, as he has produced no evidence that the former president has even attempted to invoke executive privilege about anything related to his former trade advisor, either directly or indirectly. And the current president has stated clearly that he is not asserting the privilege for either witness with respect to subjects under investigation by the Select Committee. Unfortunately, Mr. Scavino and Mr. Navarro persist in clinging to a flimsy shield. Fine, if you want to make those claims, come in, take an oath, take a seat, and make those claims on the record on a question-by-question basis. But since they won't explain it to us, they'll need to be accountable to a federal judge instead. Mr. Scavino and Mr. Navarro have a legal obligation to comply with the congressional subpoenas issued by the Select Committee. Instead, they're acting like they believe they are above the law. If we fail to cite them for contempt, we weaken this institution, not just today, but a month from now, a year from now, and going forward. All members should keep that in mind as you consider this resolution. I ask respectfully that you bring this measure to the floor swiftly for the House's consideration. I thank you and yield back.
Thank you very much.